Good evening, everyone, and welcome to this Bar Standards Board webinar. My name's Ewan MacLeod. I'm Director of Strategy, Policy and Insights at the Bar Standards Board. I'd like to start by saying thank you very much for signing up for this event this evening. We're really pleased that so many people are joining us. There's been a lot of interest in the BSB's guidance on the use of AI and other technology, so we're really glad to have an opportunity to talk to people about it. By way of introduction, today what we want to do is give you an overview of the guidance on use of AI and other technologies, and then we'll answer your questions in the Q&A session. So my colleague Henry Fingerhut is the policy lead on our AI work. He's going to provide the main presentation. And my colleague Theo Smith, Policy Officer, will then chair the Q&A session that follows. And we also have from our comms team, Sim and Cerise online to help us with any technical issues that we might encounter. So without any further ado, I'll hand over to Henry.
Thanks very much, Ewan, and good evening, everybody. Thank you very much for joining us. We're really excited to share our AI guidance with you today. But in particular, we'll obviously spend the bulk of our discussion talking about our AI guidance, but we want to first start with a little bit of general information about our approach to technology and innovation, what we're trying to do with this work stream, and indeed with the guidance itself, because that really sets the context for the guidance and for the way that we've structured it and what we're looking to achieve in order to affect good AI use, high quality AI use at the bar that advances client interests and the public interest. We'll obviously then try to open up to as much time as possible for questions and your thoughts, and we're really looking forward to an interactive session toward the end of today's presentation. So what is our approach to technology and innovation? Why are we doing this work in general, and why have we issued the AI guidance now? Well, technology impacts the bar in a wide range of ways. Most attention is, of course, rightly focused on the impacts and the risks of direct adoption of technology by barristers. But we try to take a holistic view, and we try to zoom out from that direct adoption piece all the way to the right on the screen to ensure that we can help the bar address the wide range of impacts technology can have, both on the profession and on clients and on the public interest. And that's whether or not barristers adopt technology themselves. You can see, obviously, there's a bit of a spectrum here on the bottom of the screen from those very proactive actions that barristers could be doing. That's primarily the direct adoption of technology. But even when barristers don't adopt technology themselves, they still, to a certain degree, must be responsive to various changes in whether those are changes in society or impacts of technology on a barrister's practice, that through this guidance and through our work in general, we really try to help barristers manage, respond to, and indeed, where possible, capture opportunities. And so on the very right-hand side of the screen, those are primarily what you might envisage when we're talking about the AI guidance and adoption of AI tools by barristers. But on the left-hand side of your screen, you may be thinking about those broad changes around technology and society, the fact that in only 3.5 years, there's been a significant shift in society toward the use of AI, and obviously we are responsive to a certain degree, and barristers, of course, are responsive to a certain degree to that, primarily because it comes into the legal services sector, as we've seen over the past 3 years in particular. When we're talking about impacts of technology on a barrister's practice, those may include things like cybersecurity shocks, but in the case of AI, that may be when clients or solicitors or opposing counsel use AI, and helping barristers, we try to help barristers prepare and as a result respond to those types of shocks, those types of changes that may impact their practice and may impact how they carry out a matter. Of course, right in the middle there, there's also the work that we're trying to do as a regulator on innovation, how we're trying to use technology to improve our regulatory decisions and to improve our service both to the bar and to the public at large. And in today's webinar, which is reaching currently 150 or so of you completely virtually, is a great example of that. As a result, this wide range of impacts raises key questions both for barristers and for us. So first, for barristers and chambers, these questions are how barristers might then incorporate the impacts of new technology in practice. And then for us at the BSB, there's a broader question of how we can support innovation that drives positive and safe outcomes for clients, and of course advances the public interest. So how do we do all that in practice in a day-to-day standpoint? Well, we do a wide range of activities, most of which are not formal policy, most of which are not issuing guidance, although that's obviously the bulk of what we're looking to talk about today. But we do a wide range of evidence gathering activities as well as stakeholder engagement activities. And these very much impact both our work. So that work impacts our policy response, the way that we structure policies like the AI guidance, because as an evidence-based and risk-based regulator, we do very much try to ensure that the work that we're doing is supported by research evidence. But then it also that work also in and of itself helps, and we hope helps support the sector in terms, for example, of the evidence gathering work, ensuring that that barristers are aware of, understand, and as a result can manage the impacts that technology has on their practice. So we do a wide range of both formal and informal evidence gathering, as well as formal and informal stakeholder engagement. And the one thing that I'd like to point your attention to in particular is the technology at the bar research that we issued in May of last year. And that research in particular was the first study to look specifically at how barristers and how the bar uses technology, because most of what we know about technology use in legal services comes from the solicitor market. And that research was really pivotal for informing our policy approach, and indeed the approach that we take in the AI guidance, because we understand as a result of that research that there are very significant structural differences in how technology impacts the bar. And we have to make sure as a result that the work that we do in policy work and the AI guidance, for example, that we've issued is structured in a way to both respond to and appropriately manage those the mechanisms, those unique mechanisms at the bar. So on to, of course, the AI guidance, which is the star of the show. It's the reason why most of you all are here, of course. And we'd like to really with this work provide a little bit of context for how we've structured the AI guidance, why we've done it this way, and obviously walk you through that structure and the key provisions within the guidance. Our guidance has been in progress in some sense since AI came into the legal scene in about the first quarter, second quarter of 2023, with the first cases when the first cases began to emerge in the U.S. And so we've been tracking and observing and making sure that we're monitoring risk since that time. We observed those cases that began to occur in the U.S. and we issued in October of 2023 a rapid response web publication, effectively, that sets out kind of key principles, key considerations that barristers may wish to consider when using AI. So we've been effectively trying to take a risk-based approach and scale our risk response in accordance with the risk that we observe in the sector. Now, in about May 2025, as I mentioned, we issued our technology at the bar research, and that was the first time that we really had formal evidence as to how barristers adopt technologies, including AI. the mechanisms of adoption and indeed the barriers to adoption of AI. And that time also corresponded to, in May 2025, the first cases that were observed in the UK jurisdictions. So that is, in effect, where we began to scale up our response in some sense to that increased degree of risk and increased gap, increased need that we observed with the technology at the bar research, and as a result began work on our guidance. We carried out basically a year of drafting, of revision, of stakeholder engagement informally to ensure that the guidance does respond to those issues, both that we're observing in the sector, the risk around AI, as well as the needs identified in the tech at the bar research. And we've basically had a year worth of drafting, stakeholder engagement, and we launched that guidance in May of this year. Now, I mentioned that we responded to the needs identified and the challenges identified in the tech at the bar research. What does that mean in practice? Well, as with any code guidance that we set out at the BSB, our AI guidance sets out the practical regulatory expectations for barristers using AI and sets out our interpretation of our handbook rules and core duties when barristers are using AI. But because of those gaps and challenges in adopting technology that we identified in our tech at the bar research, as compared with, for example, the solicitors market and solicitors firms, we tried to go a step further with this guidance to do two things. First, to complement existing guidance from other relevant organizations and to signpost barristers and chambers to those documents and to those regulatory frameworks that may exist, whether that is the judiciary guidance, which indirectly impacts barristers as court users because it sets out how judges in the court system are expected to treat AI used by court users, as well as responsibilities under, for example, the ICO responsibilities around data management. And then we try to go a step further still, and we try to bring barristers along in AI use principles and AI risk management principles that they may not, as a result, have had as a result of the differences between the structures and resources on the solicitor side and at the bar that may not have necessarily recourse to. And so we try to bring barristers along and signpost various risk management and technology management considerations. And we structure our guidance in a way accordingly, again, to help barristers manage those risks and adopt technology confidently and safely. As a result, we structured our guidance along a spectrum of stages of AI adoption. The aim with this structure is to encourage barristers to identify and consider good innovation practices and to shift risk away from the point of use toward upstream practices that help barristers identify and reduce the risk at that point of use. So we've structured it we've given a considerable number of both interpretations of our rules, but also key principles and good practices that are well upstream of that point of use when a barrister may be considering using technology in a particular client's matters toward the general competence considerations, the general procurement considerations, and the general technology management and policy setting considerations well in advance of that time when they're considering using AI for a particular client, in order again to help lower the risk temperature in some sense and to help manage that risk earlier. This structure, at the same time, corresponds to regulatory themes and existing duties under the BSB handbook, including expectations of competence, practice management, and chambers management, that exist throughout our handbook, and again help barristers securely manage and confidently manage AI technologies well in advance of the time that they're using it directly with clients. And the other key aspect that we try to highlight is that barristers have certain responsibilities when others use AI, and that again includes solicitors, clients, opposing counsel, and indeed judges. And we encourage barristers to be aware of the the risks that may occur when those other parties, those counterparties, use AI or other technologies, and as a result, to be able to manage them confidently. So I just want to walk through a few of the key provisions within each of those sections, and again point you to those relevant sections within the guidance, so that you can then take the guidance on and read it in your own time, and go into further detail on the recommendations within the guidance. The first is that we encourage barristers to take a risk-based approach to AI guidance, which is not to say that that the benefits of AI justify a certain level of risk, but we want barristers to be considering the risks associated with the technologies that they use, and to ensure that those risks are well managed relative to the potential benefits that they expect to see. Again, these are things that we encourage; they're not things that we require, but we try to structure the guidance in this way in order, again, to help barristers consider those general innovation good practices that exist in other sectors, and try to help signpost barristers to those other resources and approaches. And risk, as we set it out in the guidance, really takes three different dimensions, and those three dimensions together impact the likelihood and the impact of potential harms that AI can cause. We break out those risks into three areas. One's the risks related to the application, so what the technology is being used for, the risks related to the use, so how a technology is being used, and the risks related to the technology itself, which include things like the types of things that the technology is designed to do, as well as the data handling risks and confidentiality risks inherent to that technology. Now, why do we set this out in these three ways? It's because the intersection of those three have a significant impact on the likelihood of harm. So to give an example, you have on the relatively low risk side of the spectrum, you have things like spelling and grammar tools, particularly those if they're designed with high levels of data protection. Now, those may be relatively low risk types of technologies, both from the standpoint of what they do and the way that they manage data to do it. But when using those technologies, if those are used for administrative tasks, which are also relatively low risk, things like scheduling emails, that might be a relatively low risk and a relatively positive application of AI technologies. Though the risk of those same technologies, those same spelling and grammar tools, when used for things like court submissions, become potentially higher risk because of the potential impacts they may have on the content of those submissions, as well as the potential data leakage issues that they may have if those tools that aren't completely secure from a data protection standpoint. And then in particular, they may be even higher risk when used for vulnerable clients, where the tool may exhibit some bias, and we know obviously that AI tools in general often may exhibit bias. And so it's important to consider these three different dimensions of risk when coming to an overall picture of the risk that an AI tool is likely to have in them, and the potential harms that it may have on a particular client and for a particular matter. As a result, so we set out, so given that general overview and that general consideration that we encourage barristers to take, and again, we encourage that, we don't require it, we set out a number of key provisions under each of those stages of technology adoption. Some of these are indeed requirements, and those are typically the ones in bold on this slide. And the reason that those are requirements is that they derive directly from the rules in the BSB handbook. And the key ones I'd like to point out here is that barristers must and do indeed retain personal responsibility for all of their work, even when using AI technologies or other types of services, and that derives directly from the personal responsibility provisions within the BSB handbook. And barristers also must be transparent about the use of AI, particularly to their clients, if it has a significant impact on the nature and scope of barrister's legal service. And that again derives directly from the requirements in the BSB handbook not to mislead clients about the nature and scope of the barrister's service. Beyond that, we do a number of other things, and beyond that, basically, we encourage barristers in other areas to consider other types of protections and other types of practices that you can carry out in order to manage AI risk safely. And those are things like maintaining a basic degree of technology competence to understand its impacts on a particular matter that you may be dealing with, even if you're not using AI yourself, because again, of that mechanism where clients may be using AI and it may, as a result, impact on the privilege of the document that you provide to them, or indeed that opposing counsel may use AI, and if they use it improperly, well, then that may provide an advantage may provide a point that you may need to raise on behalf of your client. And then when adopting technologies yourself, gaining further competence in those technologies to ensure that you're able to adopt them securely and safely. And those are all, generally speaking, provisions before procurement and adoption of technology. Then after adoption of technology procurement, we encourage barristers, again, before the point of use, to consider technology management and use procedures that can help you manage the technology safely and use it safely, effectively setting appropriate bounds for the AI use. And that may be through a more or less formal data governance or AI governance policy that you may set out within chambers, for example, or that may be sort of an informal playbook or some sort of general kind of boundaries of use to ensure that when it does come time to use technology, that you're using within the degree of the spectrum of use that you expect, and that the AI performs in a way that you're expecting. Then when using AI at the point of use, there are additional duties which derive again from the responsibilities that barristers have to their clients at all times. And those again are that barristers are responsible for your own work at all times. We encourage you to ensure that the AI use that you're considering is in your client's best interest because of your general duty to act in your client's best interest. And of course, you must ensure that the use of AI that you're considering adheres to not just BSB conduct rules, but also court practice rules and other regulations that you may be subject to, which include things like ICO, data management regulations. And then when others use AI, we also wanted to highlight that it's important to be aware that others may use AI and understand how that may impact the matter, again, whether or not you use AI yourself. And then particularly for those barristers that work under direct access, we wanted to highlight in particular the fact that clients may access barristers directly when relying on AI to carry out the types of tasks that solicitors might traditionally carry out. And we encourage you to consider whether that, if you suspect that a client may be relying on AI in that way, consider whether that arrangement is in the best interests of your client, and as a result, consider whether that instruction is appropriate under the direct access rules that we have. So that is a very high level overview of some of the key provisions that we have, again, at all stages in AI adoption within the guidance. It's important, I think, not by any means to rely on anything that I've just said. Again, this is an overview. It's important to go and look directly at the guidance to understand it. And importantly, I want to highlight that we're very much available and very much interested to engage and hear your feedback and your thoughts based on your use.
I think just one concluding thought from me is that we've talked a lot about risk and managing risk this evening, and obviously that's important. But I was struck on the Slido that we did earlier that the biggest word that came up was opportunity. And I think it's important to remember that there are opportunities here as well as risks. And we do say on our website that used safely and effectively, technology can enhance access, quality, and client experience and create new opportunities for barristers to meet clients' needs. And I think as we move into this brave new world, it's important to remember the opportunities as well as the risks. And as I said before, this guidance was very much a first step from our point of view, and we really welcome feedback on it. If there are areas where you think we need to provide additional guidance or FAQs or anything like that, then please let us know. We will continue to work with the Bar Council and others to identify opportunities to further support the profession in this area. So I'll just say one final thank you to the team here for helping us to put this event on, and to all of you who've stuck around till the bitter end. Thank you very much, and do watch this space. As we said earlier, we'll be planning an in-person event in the not too distant future. So we hope that people will be interested in that too. So good night, everyone. Thank you.